Hello, everyone out there in the United States and offshore and here in California. And it's nice and warm. We're here for the compliance webinar today about the TCPA Havoc and the super sacred cell phone. I'm going to be talking about the death of the EBR, new rules that are going into place that are changing the contact center industry quite drastically. So we're going to get started here in a couple minutes. We've got a lot of people joining, so we're going to give people a chance to catch up, but we're going to kind of jump right into some of the agenda and just some of the housekeeping things right now. As far as the webinar today, most people have been on these before. It's pretty straightforward to ask questions on a webinar, which is just text them in the GoToWebinar chat function that you'll see, and we'll have about 10-15 minutes at the end to go through questions. We're going to have about 50 minutes of content today. We've got the call being recorded, so if you miss anything or have to leave early, we'll also be able to get the slides out to folks because obviously this is important legal information. And we're fortunate today here to have myself. I'm Ryan Thurman with Contact Center Compliance and Eric Allen with Allen Legal Services to help kind of break down these rules. Eric's a foremost expert in telemarketing compliance, collection compliance. He knows the TCPA. He's got a lot of clients that he works with that we also work with that help them on the more on the data compliance side. We ourselves are heavily involved in TCPA because we do TCPA scrubbing, so we've had to really get our compliance rules and our guide in gear for these new rules. So we actually have been relying on Eric to funnel that information. So without further ado, I'm going to turn it over to Eric and let him kind of get started and getting into this information because we've got quite a lot of bit of information. It's actually confusing to myself, even being in the industry. So it's a pleasure to have Eric join us. Thank you.
Thank you, Ryan. Much of it confusing to me as well. Sometimes I have to re-review my own notes and make phone calls to make sure I still understand the new rules. Well, good morning, everybody, or good afternoon, depending on where you're at. My firm, Allen Legal, as Ryan mentioned, we're kind of a business side telemarketing compliance firm. We get sucked into litigation occasionally in defending call centers, but the bulk of our work is on the front end compliance infrastructure setup and counseling. We're a small firm, 3 attorneys, just hired our 4th based out of Salt Lake City, but have call center clients across the United States and Canada. We'll jump right in. TCPA Havoc, the super sacred cell phone. And where in the world did EBR go? Quick outline. We're going to talk about the new rules. Some of these amendments are already in effect, but some of them, including the tougher ones, are going into effect in less than a month on October the 16th. So we're going to talk about what the new rules require. We're going to talk about the death of EBR for autodialers, at least in certain contexts. Why and how you should identify and scrub out wireless numbers, possible exemptions to the new rules, how to obtain written consent that will allow you to keep calling cell phones and doing what you want to do despite the new prohibitions. We'll talk about why preview mode, or some people call it click-to-call, is not quite as safe as you think, and we'll give some suggestions on how you might deal with a dialer in preview mode and maybe stay safe if you can. How calls to landlines are affected, how B2B is affected. We'll talk about the implications, the fines and penalties, and the consumer's private right of action under the TCPA. And finally, we'll talk about dealing with TCPA suits or threats, demand letters, government investigations, etc. By the way, I'm assuming you can see what I see on my screen. If you can't see the slides or if they're not advancing, post a message for Ryan or text him and we'll get it straightened out. What do the new TCPA rules require? First and foremost, the big nasty, prior express written consent for automated telemarketing calls to cell phones. Now I've got to be careful with my terminology because when I say autodialer or robocall, I might be thinking of something a little different than what you imagine. When I say an auto-dialed call, I'm speaking very broadly. Any type of auto-dialed call, any type of ATDS is the term the government uses, automatic telephone dialing system. It could deliver a pre-recorded message. It might just be a predictive call where the software is dialing predictively and connecting live answers to the call center agents, etc. But these new regulations apply. If we want to be technical and accurate, these regulations target calls initiated by ATDS, automatic telephone dialing systems. So you're going to need prior express written consent for calls made using an ATDS to any cell phone, telemarketing calls anyway. Next, you will also need prior express written consent for pre-recorded telemarketing calls to consumer residents, to landlines. Notice that the new rule on robocalls to landlines, that does not apply to all ATDS. In this case, it's a restriction on pre-recorded messages specifically, and pre-recorded messages that deliver a telemarketing solicitation in particular. Also, there's no more EBR exemption in this context like there used to be. Still an exemption to the national no-call list, but no longer an exemption to the robocall rules. We'll explain that further in a moment. There are also new rules about what prior consent means and how you can obtain that. What does it mean to get prior expressed written consent so that you can keep auto-dialing cell phones and consumer landlines? We'll talk about that. A couple of rules. This is part of the amended TCPA, but these last two are already in effect. You need to use a special opt-out now on your pre-recorded messages. You have to use an automated interactive voice response or key press opt-out option on pre-recorded calls. Also, if it is conceivable that your message might be picked up by an answering machine or left on a voicemail, then in addition to that, you have to disclose a toll-free number that the call recipient can use to call back during their local business hours and make an opt-out request. The reason for that being, of course, that if a consumer is listening to your pre-recorded marketing message on their voicemail, they're not on live with you and can't make the automatic opt-out. They have to have a way to call back and make the opt-out request at a later time. Also, the abandoned call rules have been tweaked, and I believe this was meant to try and harmonize these rules with the abandonment rules of the FTC in their TSR, the telemarketing sales rule. For those of you who aren't familiar with predictive dialing and abandoned calls, the abandoned call rules apply primarily to predictive dialing, where your dialing software is constantly initiating more outbound calls than you have live agents available at any given time. So it's dialing numbers, and then it's trying to predict when the consumer will answer and then connect the call recipient or consumer to the live agent upon the answer. So because of that, you get ring, 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 the consumer answer says hello, and then the software tries to connect that call to your call center agent. However, with all abandoned calls, there will always be some level of drop rate or abandonment rate when the consumer says hello and you don't have a live agent ready at that time. That's an abandoned call, and technically the government considers the call abandoned if you don't connect them to a live agent within 2 seconds after the call recipient's completed greeting, meaning ring, 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 hi, this is Eric, 1-1000, 2-1000, dropped. If you don't have a live agent on, then then it's an abandoned call, and you got to comply with this rule. Under the new rules, you are not allowed to abandon more than 3% of answered calls. And that's measured, and this is the change, that's measured on a successive 30-day per individual calling campaign basis. And that's new. You can no longer measure your abandonment rate across multiple campaigns or all campaigns across your whole floor. You are going to have to track on an individual per campaign basis call abandonment. You're going to have to manage and restrict call abandonment for each particular campaign, measured on a successive 30-day basis. We're going to talk more about all of these. Okay. Let's see here. Whoops. Back into it here. The death of EBR for autodialers. Don't be confused. EBR, meaning established business relationship, remains an exemption to the national do not call list. It has been taken from us as an exemption to some of the dialer rules, and that's what I'm talking about. For those of you who need a quick EBR review, established business relationship, this is an exemption where the government has given us kind of a break from some of the telemarketing rules when we are trying to call people who already have a relationship with us somehow, or our account client, if you're a third-party call center calling on behalf of a product seller. So if someone bought something from you or made an inquiry, you get a window to call them even if they're on the no-call. So for example, you get an 18-month EBR window from the time that a consumer purchases something from you or your client. You also get a 3-month inquiry EBR window if they've inquired about your product or service, even if they didn't buy. Those remain exemptions to the national do not call list. If you call someone who has put their number on the national no call list, it's not a violation if you have that 18-month purchase EBR window or the 3-month inquiry EBR window. And for a long time, until now, EBR was also an exemption to the prohibition against delivering pre-recorded messages to landlines, and that is no longer the case as of October 16th. Why does that suck? Well, it means you can't just blast with pre-recorded the landlines of your existing customer base or your inquiries or no-buys. You know, if you're keeping track of your EBR windows based on various triggers, it used to be that got you around the national no-call list and some of these dialer restrictions. That's no longer the case. EBR remains an exemption to the national do not call list, but it's no longer a loophole to reaching out to your EBRs using a robocall to a landline. So again, still gets you around D&C in a limited way, but it is no longer an exemption to the restriction on the delivery of a pre-recorded telemarketing message to a consumer's landline. Be aware of that. You're going to need to re-engage with your past purchasers and existing customer base in a new and different way. We'll talk about that in a moment. Why and how should you identify wireless numbers and scrub them out? Well, why? Because unless you have the proper consent, the general rule is you may not auto-dial cell phones for telemarketing purposes. Proper written consent is hard to obtain under the new rules. We're going to go through their definition of what they mean by prior express written consent and talk about why it's a little harder to get. A lot of this so-called, quote-unquote opt-in data floating around the industry is just not going to fly anymore after October the 16th. We'll talk about how the new consent standard is higher and more rigorous. Also, of course, significant fines and penalties. Consumers have a private right of action under the TCPA to sue. There's the ever-present threat of TCPA class actions, which are stressful and distracting and costly to deal with, win or lose. How do you identify and scrub wireless numbers? Well, of course, you can do that in-house, or there are a number of great vendors in our industry now that offer wireless identification and scrubbing services. Obviously, our host and sponsor today, DNC.com, is one of those great vendors. Call Ryan Thurman. He could tell you about what they offer and explain better than I could what wireless identification scrubbing services they offer, in addition to, of course, the DNC scrubbing they've done for many years. What do you need to scrub against? Well, first you need to compare your list to what I would call the carrier file. Ryan might be able to explain this better than me, but this is kind of the wireless block file. This is a list of all wireless number prefixes. At least that's my understanding.
Right. So
let me right, Ryan? Can you
let me just elaborate on that. It's actually done by the first 7 digits of a phone number. So it's the prefixes plus 1 digit is really the most accurate way to do it, and that's for the numbers that are owned by the wireless companies themselves. And then they expand those as needed, so that does change kind of on a monthly basis. We have a really good way to bring that in, either to scrub or we provide that data to companies that use it on their own platforms. And then you've also got, of course, then the new star data that you have to overlay, which are the ported numbers, which porting is from wire lines to wireless or from wireless to wireline. So basically you can take your home phone number that if you had for years, a copper line, and then port that to a cell phone number. And so Neustar is in charge of managing that data through the FCC. So in order to get that data, you have to go through a reseller, et cetera, and be able to pull that data in for numbers that go over to cell phone or go back to landline. There's about 5.5 million on Neustar's ported list and about 500,000 numbers that have actually gone back to landline. Whereas that's a smaller part of the cell phone world. Like I said, the carrier data that you mentioned, that's the compromises 300 million plus phone numbers. So it's a much more broader approach. But I mean, what does that do to a database when you scrub it? If you take a list, like you're talking about, why does this suck? Why companies are really concerned about this. You take a list of those customers, people that you're going to call on your dialer, typically run it for just the wireless ID. You're going to match 50, maybe 70% of your records. I talked to customers yesterday that it's entirely cell phone, and so you take that amount away where now it's you can't put it through an automated system, and that does suck. So
two separate lists. In any case, you've got this wireless block list or the carrier file, and you've got the Neustar or ported number list, and you'll need to scrub both or compare your calling list to both to make sure you're not calling cell phones. There is, and this is not a new rule, there have been restrictions on auto-dialing cell phone numbers prior to October the 16th, of course, but they're tougher now. Even under the previous rule, there's this limited 15-day safe harbor, which basically meant if you had good procedures in place to scrub out wireless numbers and you accidentally called a number you thought was a landline, it turned out to be a cell phone. As long as you had scrubbed against these wireless files, within the previous 15 days, you got kind of a safe harbor exemption. I've been not super careful about the way I describe this because under the new rule, I don't see this exemption applying to telemarketing calls. So be aware that telemarketer, that may be different for informational callers or people who are not calling for a commercial reason. But if you're a telemarketer, you want to try and scrub more frequently than every 15 days. Every day if possible. You want to do everything in your power to make sure you don't call cell phone numbers, period, without the proper consent. What are some exemptions to the new rules? I tried to break this down between cell phones and landlines here. Of course, first and foremost, prior express written consent for telemarketing calls made to cell phones using an ATDS, automatic telephone dialing system. If you can get the proper written consent, which we'll explain what that means in a moment, but if you get the right consent, then you can continue to use an auto dialer to solicit to individuals on their cell phones. Prior express consent, not written, doesn't need to be written for non-telemarketing robocalls and calls from tax-exempt nonprofits. Now, this is not a change. This was the same under the old rules. If you're not calling for a telemarketing purpose, or if it's a tax-exempt nonprofit call, you may need consent. You just don't need the new rigorous written consent. Also, certain HIPAA-regulated calls, again, may need consent but not written. But keep in mind, my understanding is that the reason for this HIPAA exemption is that HIPAA already requires, for example, medical providers or health care plans. HIPAA already requires those entities to obtain prior written consent in order to use a patient or a policyholder's information, including their private contact information, for marketing purposes. So in an attempt to avoid that redundancy, certain HIPAA-regulated calls are going to be exempt from the TCPA's new written consent rules. Regarding landlines, again, prior express written consent, always at the top of the list. Calls made for emergency purposes, calls not made for a commercial purpose. So if your call has no underlying commercial purpose, also calls that might have a commercial purpose, meaning there's some underlying for-profit reason you're making the call, you're making money somehow, but the calls themselves do not introduce an advertisement or constitute telemarketing. So there may be a for-profit underlying purpose, but it's not really telemarketing. Be very careful. The feds have a very broad definition of telemarketing. You'll want to do your homework or consult with counsel if you're going to rely on that exemption. Calls made by or on behalf of a tax-exempt nonprofit, and then finally, once again, certain HIPAA-related calls are exempt. How do you obtain sufficient written consent? Well, let's read the rule first, and then we'll break it down for you. Now, these come not out of the actual TCPA, the statute, but out of the CFRs, the regulations that flesh out the statute. These are published by the FCC with authority from Congress, who passed the Telephone Consumer Protection Act. The term prior express written consent means an agreement in writing bearing the signature of the person called that clearly authorizes the seller to deliver or cause to be delivered to the person called advertisements or telemarketing messages using an automatic telephone dialing system or an artificial or pre-recorded voice, and the telephone number to which the signatory authorizes such advertisements or telemarketing messages to be delivered. 1, the written agreement shall include a clear and conspicuous disclosure informing the person signing that, A, by executing the agreement, they're authorizing the seller to deliver or cause to be delivered to the signatory telemarketing calls using an ATDS or artificial or pre-recorded voice, and B, the person's not required to sign the agreement or directly or indirectly or agree to enter into such an agreement as a condition of purchasing any property, goods, or services. Oh, that's a mouthful. Let's see what this means here. What did you notice? What are the requirements? Well, you need a written agreement that includes the signature of the person to be called. Thankfully, elsewhere, the FCC has indicated that you don't need ink on paper. An electronic signature is sufficient, and that's because of the Federal e-Sign Act, or there's a variety of state laws that also recognize various types of signatures other than, putting pen to paper and physically signing your name. So a written agreement that includes a signature, but it can be an electronic signature. The agreement must indicate the specific seller or specific sellers to whom consent is being provided. There's a big implication here. Under this definition of prior written consent, it can't be generic, shareable, not easily transferable. And this is tough for online lead generators who want to go generate opt-ins and then sell it to all sorts of companies they might not even be working with at the time the consumer provided the opt-in. That doesn't fly anymore because the consumer needs to indicate who specifically can call them, which sellers or which telemarketers. So your consent language is going to need to spell out or list who can call you. It can't just be anybody. We're going to share some examples of different types of consent blocks or paragraphs that you might consider using. So bottom line is consent needs to be seller or telemarketer specific. Next, the agreement must include the telephone number to be called. So the consent needs to be telephone number specific as well. The consent isn't just tied to an individual. It can't just be, oh, Eric said we could call him using an ATDS for marketing purposes. It's got to be Eric said he could call us on this line or these lines, including the cell phone if that's the case. So your consent language should spell out which number the consumer is authorizing calls to be initiated to. Next, the person must take some affirmative action to clearly, expressly indicate their consent. This is why the government doesn't like sweepstakes forms or hiding it in the fine print in your privacy policy or terms of service or terms of use. The consumer needs to take an affirmative, ideally a purpose-specific action to show they're specifically consenting to receive these calls. And to review the disclosures, you've got to tell the consumer that they're authorizing you to make telemarketing calls, that the calls might be placed using an automatic telephone dialing system, including a pre-recorded message, if applicable. And you have to specifically tell the consenter that they are not required to consent in order to purchase. Notice that this is an affirmative disclosure rule. The rule is not merely that you can't require consent for them to make a purchase or to participate. That's not the end of it. You have to tell them that. So even if you would never in a million years require consent in order for your customer to purchase or participate in your promotion or whatever, you have to tell them that anyway. I see this left out of consent language all the time. Even if you're not requiring consent as a condition of purchase, you still have to say it, or it's not compliant. Methods of obtaining this consent. Website option will still work if you do it right. You need proper language, an affirmative action, and you need to be able to store that consent. You need good record keeping so that you can promptly prove to a regulator or a court upon request that this person really did consent and properly did so. A paper form will work. Be careful with the sweepstakes entry forms. The government's made it clear they don't like those. They're going to scrutinize those. Doesn't mean you can't do a sweepstakes and get the right consent. It just means it's hard. Be very careful. Do your homework or consult with your telemarketing counsel if you're going to try and generate the right compliant consents using something like a sweepstakes form. You can't hide it in the fine print. Finally, live recorded consent over the phone will work. If someone, like on an inbound call, for example, if someone calls you or you're doing a customer service call, you can ask for consent to make future calls to them or on their cell phones or using an ATDS. If you do it right and if you record that, be very careful not to explode your internal D&C. When you ask someone on the phone, if you can robocall their cell phone, we've heard reports that companies are getting a lot of opt-outs. You don't want to be forced to add that person to your internal no-call list. So be very careful. Train your agents properly and to get the script right so that you don't explode your internal D&C if you're trying to generate consent over the phone and recording that. There are other ways to do it as well. The FCC said you can get the consent through email, text, etc. Let's look at some possible consent language here. This is common on a lot of online lead gen sites and is just simply not compliant, doesn't meet the new rigorous consent standard. By clicking below, you agree to be contacted by us and our affiliates about our promotional offers. Not compliant on many different levels. This is not telephone number specific. It's not seller specific. It doesn't disclose they're not required to consent to purchase. It doesn't disclose that you're going to be using automated technology. Just not compliant at all. Let's look at the next one. This is kind of big and scary, but would certainly be compliant. By clicking the Submit button below, I expressly authorize, and then you'd want to list the specific sellers to deliver or cause to be delivered telemarketing calls, pre-recorded messages, and SMS text messages regarding their products and services using an automatic telephone dialing system or an artificial or pre-recorded voice to me at the telephone number I entered above, and then ideally you'd want to try and auto-populate that down from the form they filled out above. Even if this number is a mobile number, I understand that I'm not required to give my consent as a condition of purchasing any property, goods, or services. This is just kind of taken the language right out of the statute and thrown it on your form. That is kind of scary. I could see how that would frighten certain prospects off. But what about maybe a compromise? Can we tone down some of the language? The stuff in the statute there isn't contained in quotations, really, so you've got some flexibility, but realize there's a liability spectrum here. The further you deviate from their language, the more riskier it is. They might not think it complies. But consider this, which I think is likely compliant and much less scary. This is the last bullet. By clicking the Submit button below, I expressly authorize ABC LLC to call me or send me recorded messages or texts about their products using automated technology to my telephone/cellular number I entered above. I understand that I'm not required to give my consent as a condition of any purchase. I think that's compliant as long as you do it right, as long as the language is clear and conspicuous, as long as it's it's in font that's as large and as readable as the other text on the page. It's immediately above the Submit button. And then, of course, you need to store the consent properly. Regulators and courts will not take your word for it. If you receive an AG letter or a civil investigative demand from the feds, or maybe it's you get a subpoena or something from a court. They're not going to take your word for it. You can't just say, oh, look, this is what our website looks like now, and this is a copy of the consent language that we presented them with back in the day, and this is the day they consented. I mean, they're not just going to take your word for it. You need to store this consent in a better manner. You need to capture IP address if you can. You want to time and date stamp the consent record. You want to capture a screenshot or have some way of storing a picture of exactly what the consumer saw when they consented. And you want to have that stored and cataloged in such a way that you can immediately generate for a regulator upon request something, some paper report showing exactly the time and date when they consented, IP address, this is the form they filled out, this is what they typed into those fields, this is a shot of exactly what they saw when they clicked submit, and that's how you know we had the right consent. You need good record keeping. You want to store that for at least 5 years. I would say even 7. I know some state telemarketing statutes have a 7-year statute of limitations. So at a bare minimum, store that consent for 5 years, I would say.
Hey, Eric, there's a question that came in that I think is a good one that kind of interlace at this point, which is, what about the getting recorded consent? Can you offer like some tips or kind of a sample recorded script? Because that's the one we also get the most questions on, is like, can you do this over the phone? How does that work? Will it stand up in court, etc.?
Yeah, you sure can, and it's tricky though. Not just because you're at risk of blowing up your internal D&C when people say, no, don't call me after you ask them that. Does that mean you got to put them on your internal D&C? Probably, yeah. I mean, you got to be careful, but also because of record-keeping reasons and just the scripting itself. How would that go? Well, it might go something like, I don't know. Hey, Eric, while I've got you on the phone, one more thing. There's never any requirement to consent in order to, there's never any requirement to consent to our marketing in order to purchase from us, but would it be all right if we here at Allen Legal, called you, about our offers using some automated technology, including text or pre-recorded messages once in a while? Would that be okay? Wonderful. But then if they say no, you want to follow up. You want to say, okay, that's no problem, but just to confirm, can we still call you as long as we don't use automated technology? I mean, you want to, and again, I'm not putting my stamp of approval on that, but you want to be careful with how you do it. You want to record it so that if a regulator says, okay, prove to us they consented, you're going to produce the recording, and they're going to be able to listen and agree with you and say, yeah, you're right. That constitutes a written consent, and they said an affirmative yes. It wasn't just an uh-huh or make sure you get an affirmative answer. Make sure your scripting is good and your agents are trained very well, because if you don't train them right and you don't have a good script, then A, it might not constitute proper written consent, and B, you might really just explode your internal D&C list, and then you're losing callable numbers. There's probably a lot more I could say on that. Depending upon specifically what you're selling and who you're calling and what you're doing, you need a very custom script for that. So be aware you can't. The bottom line is, yes, you can absolutely get prior express written consent on like a digitally recorded live telephone conversation if you do it right. But regarding particular situations, we'd want to sit down with you and go through that and make sure you've got something that's compliant under your specific scenario, and we'd want to make sure your record keeping is on par.
And somebody made the comment that and this does make sense too, you'd want to make the call whether you got prior express consent or you really did get some sort of a written consent that would fall out and hold up, because a lot of times, you might not be getting the consent with all the disclosures that Eric mentioned, because it's pretty lengthy.
Correct. Yeah, that's absolutely right. You may end up getting a bunch of consents that would work under the old standard, but not the new written consent standard. Also, be aware, of course, the government is wise on this. You can't make an illegal call to someone and then during that phone call ask for consent. The consent is not retroactive. The word prior is in there. I've seen people that they'll get had one earlier this year. Company came to us, they've been sued, and their lead generator had done some billboard advertising or something, and they were making follow-up calls, but those calls were made in violation, and then during that call they were trying to obtain the right consent. Doesn't fly. You can't make an illegal telephone call to someone and then ask for permission retroactively, because you've got the next call might be compliant, but that call, the initial call you made, if it was made using an ATDS and without the right consent, then that might be a violation. So be aware of that as well. Preview mode. Everybody wants to say, well, I do click-to-call or preview, and we're not doing any real auto dialing in the traditional sense. So my dialing is manual. It's not auto dialing. I can ignore these rules. Hold on. That's not necessarily the case. Let's look at what is an automatic telephone dialing system. An ATDS, according to the FCC, is equipment that has the capacity to store or produce telephone numbers to be called using a random or sequential number generator and to dial such numbers. Now, the first time you read that, if you're like me, well, nobody does that anymore. That's not talking about me. We don't do random or sequential generation or dialing. Nobody does that. I'm not doing that. I'm not an ATDS. Well, how they get you is the word capacity. The trigger is not that you're actually auto-dialing or doing random or sequential generation or dialing. The trigger is if your software or your system has the capacity to auto-dial. And separately, in their enforcement actions and other rulings, the FCC has emphasized that this definition covers any software which has the capacity to auto-dial, to dial without human intervention, regardless of whether the numbers called are randomly or sequentially generated, or you're just calling on a lead list, for example. So capacity is the key. This means there's a risk even when you're doing preview or click-to-call mode. The risk is that depending on your specific dialing platform, or if you're using your CRM or whatever it is, if your dialer has a capacity, then you risk a regulator or a court saying, oh, I disagree with you. I think your method of preview dialing is actually auto-dialing. There are some important cases, some of them recent, that explore this. The Nelson case down below there, Nelson versus Santander Consumer USA. This ruling came out, well, this court decision, rather, the judgment came out, I want to say March of this year. I think this was a Wisconsin district court case. A court in Wisconsin awarded a woman, just one individual consumer, over $500,000 based upon a large volume of not just pre-recorded, but a lot of preview dialed calls without consent. Now, the court in that case held that it didn't matter that a lot of those calls, well, this is what the defendant argued. Santander had argued that, look, yeah, some of our calls were, robo pre-recorded, but a lot of our calls were not. A lot of our calls were manual because we were doing preview mode. And the plaintiff hasn't proved, which were manual and which were robocall. Therefore, at least a lot of these calls, may not have been in violation, and they shouldn't be able to win on summary judgment. The court said, no, I don't care. I don't care that maybe most or all these, or maybe many, if not most, were preview mode calls, because the dialer itself had these other functionalities to do things like predictive and pre-recorded. Because it had the capacity to dial without human intervention, that's all I care about. Therefore, all the calls, every single one was made by an ATDS. And here's your $500,000 judgment. Now, that decision is not binding on any other courts. In fact, there was later some sort of settlement between the parties in which that decision was vacated. But the Nelson case cites and relies on a bigger case, a Ninth Circuit case, which may be binding, up and down the West Coast to a certain extent. The Satterfield case also, was about preview dialing, talked about capacity. Bottom line is, if your dialer has the capacity to dial without human intervention, even if you're not using that functionality, maybe you haven't even bought that functionality or the other licenses, you haven't turned on the auto dialer functions, If your system itself has the capacity to auto-dial, then it is an ATDS, whether you're auto-dialing or not. So even if you're using preview mode, meaning your agent, the software, all it does is throw up on the screen, the name and telephone number to be called, and then the agent hits the enter key to initiate each individual call. That's what I mean when I say preview. I know there's a ton of variants on that and hybrid approaches, but if you're doing that type of preview mode, you may think it's manual because there's human intervention in every particular call, but that's not the deciding factor here. It's capacity. Does your software itself have the capacity to do other things if you bought the other licenses and turned on the other functionality? Could it auto-dial? If it can, then it's an ATDS. That's the trigger. So scrutinize your dialing system. Do you think the government would consider it an ATDS or not? Be very careful and conservative, or you could have a lot of exposure here and get stuck with a $500,000 judgment when you thought you were doing manual. Let's move on. How are calls to landlines affected? Everybody says, oh, the new cell consent rules, the new cell phone rules, etc. Well, the new rules also affect pre-recorded telemarketing messages to landlines as well. And it sounds like this number is low, Ryan. Last I heard, maybe last year, it was my understanding that at least 1/3 of all households are now wireless-only residences. And that number has gone up a lot, it sounds like. Is that right?
I think it's closer to more like at least 50% or more.
Yeah.
I know the CDC came out with some numbers, and I think that's where it was, somewhere around there. I mean, it's come to a point where people are obviously just either getting rid of landlines altogether, or some of the reasons why you see numbers going back to landlines from cell phone is the cable companies, triple play type, Comcast bundling services. But most people, it's the porting, and that's the dangerous part of letting your data sit around too long with not scrubbing, like you're saying, daily, because
changes.
New start data changes every day, and so you've only got that 15-day window. So a lot of people leave the leads that are in there to kind of work through, and then you've got these random ports that, if you're not checking everything on some sort of periodic basis, it's easy to get sued. I mean, and they can sue you right in any court or any kind of jurisdiction. There's no limit to they have to waiting for the FTC to pick up a case or anything, right? Or the FCC.
Correct. And in fact, we'll talk about that TCPA jurisdiction in a moment. So bottom line is, most people are using their cell phones now, but still a lot of landlines out there. Marketers need to reach those landlines. Landlines will always be important. Unlike for cell phones, the TCPA still allows predictive telemarketing calls to landlines without consent, but not pre-recorded. So as the new rules relate to landlines, the government's not restricting all ATDS calls. It's restricting telemarketing pre-recorded messages in particular. So long as there's no pre-recorded message, no consent's needed to auto-dial the landline under the TCPA. For pre-recorded telemarketing messages to landlines, we'll need prior express written consent, just like for cell phones. But then again, for telemarketing versus non-telemarketing, if it's a non-telemarketing pre-recorded message, like a truly, genuinely informational non-telemarketing message, no consent's required to a landline. Be aware, some states are more restrictive. The federal rules are not the lowest common denominator just because they apply everywhere. The federal rules do not cancel out state-specific and local rules, which might be more restrictive. This is very different from email marketing and canned spam. The feds, when they passed canned spam, specifically, trumped virtually all state email marketing law. They said if you follow canned spam, state-specific email marketing law is trumped, essentially. That's not the case for telemarketing. You need to look at the federal rules, you need to look at the state rules and follow which is more restrictive. So for example, you got to follow the federal rules for every state. But if you're calling Indiana, Indiana's got some very tough state-specific robocall rules. Some of the toughest in the country. There's a handful of states that go above and beyond what the feds say, and you've got to comply with those state rules when you call into those jurisdictions. How is business-to-business marketing affected? Well, B2B always says, you know, we just call their businesses. None of this applies to us. That's not the case. For many years, and it's still the case that as a general rule, B2B gets a lot of breaks that business-to-consumer calls don't get. But some of these rules technically apply to when a business calls another business. What if your call center only wants to call business lines, or at least people that work at businesses, and you only want to talk to them in their professional capacity, and you're not interested in communicating with individual consumers? Do these new rules affect you? Let's read the rule, and you tell me what you think here, or think to yourself. No person or entity may initiate or cause to be initiated any telemarketing call that includes or introduces an advertisement or constitutes telemarketing using an automatic telephone dialing system or an artificial or pre-recorded voice to any of the lines or telephone numbers described in paragraph blah, blah, blah. And I pasted that right in here from the other section of code. The numbers that are protected include any telephone number assigned to a paging service, cellular telephone service, etc., blah, 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 other than a call made with the prior express consent of the call party. So this is not consumer specific. The rule protects cell phones and not consumers. Therefore, on its face, technically, it would protect business cell phones right along with consumer cell phones. Now, certainly, I mean, the FCC and FTC, their job is to protect consumers and not to protect businesses. And I've heard rumors that kind of offline the FCC regulators have said, we're not looking to go after B2B on this necessarily. Even if that's true, the bigger risk here is not from the FCC coming after you. It's from these private lawsuits. The TCPA, unlike the TSR, the Telemarketing Sales Rule, which is the FTC's big statute, and the FTC's been far more active in terms of filing enforcement lawsuits than other agencies. But the FCC, in the TCPA, there's this private right of action, which lets the consumer bypass the federal regulatory bodies and go right to their local courts and sue you directly for damages. So if you robocalled my cell phone without consent, even if it was primarily my business line and you're calling me because you want to sell me SEO, or you were doing a who is search and you're calling who is domain registrant data or their new business connects or whatever, you might call cell phones. Even if it is primarily a business line, you're going to need the right consent. So businesses are going to have to deal with the cell phone issue. B2B callers, rather, are going to have to deal with the cell phone issue. Note that the new rules do not protect business landlines. Under the federal rules, you will still be able to predictively dial and robocall using pre-recorded messages to business landlines even after October the 16th. I'm going to speed up here. I want to allow some time for questions. Potential fines and penalties. What happens if you step out of bounds, you break the rules, FCC calls foul? You can be fined by the government up to $16,000 per individual violation. Notice that's not per campaign or per call, it's per individual violation. Think how astronomical that could be. There's a potential for multiple violations in every single call. What if you didn't have the right consent to robocall, and then maybe you didn't have the right disclosure in there, and your opt-out wasn't proper, and maybe they worked their way through your automated system and talked to a live agent who refused to agree to send your D&C policy or whatever. You could have 4 or 5 violations in a single call. Now, most call centers are pretty good and are going to follow the rules the best they can, but what if you had a single flaw, a single minor flaw across an entire campaign? At $16,000 a pop, those fines can really stack up and be crippling. You're really at the mercy of the regulators when you're trying to negotiate down a fine that big. Also, state attorneys general can sue you over their local robocall rules, or also be aware that in some states, it's a violation of their state local law for you to violate the federal rules. So you might simultaneously break a state law or a local regulation by violating the federal rule. finally, you've got injunctions. This is not just about money. As is very common in government enforcement lawsuits, to settle those, you often have to agree to a consent decree where you agree, the court orders you, you're not allowed, Eric, to telemarket ever again, or you cannot engage in telemarketing in XYZ industries ever again. So injunctions are also possible. Let's look at the consumer's private right of action to sue you directly. This comes right out of the TCPA, not the regs, but the actual statute. A person or entity may, if otherwise permitted by the laws or rules of a court of a state, bring in an appropriate court of that state an action based on a violation of this subsection or the regulations prescribed under this subsection to enjoin the violation, or B, an action to recover for actual monetary loss from the violation or to receive $500 in damages for each violation, whichever is greater, or they can do both. And then finally, if the court finds that the defendant willfully or knowingly violated, et cetera, then the court may, in its discretion, increase the amount of the award to an amount equal to not more than 3 times the amount available. So essentially, a private individual can sue you for $500 a violation or $1,500 a violation if the call was willful. This is probably the largest risk. Most of us in the industry, most call centers don't do enough volume to really draw the attention of the feds, but a single guy out in the middle of nowhere can sue you and cause you a lot of stress and damages. The private right to sue is probably the largest risk for violators. Class actions are also possible. A class action is when the individual plaintiff adds to their civil complaint when they file it with the court language that basically says, look, Your Honor, based on the facts and circumstances, it just makes sense that there are other people out there, similarly situated victims, who've been harmed by this telemarketer in the same way. And we want you to allow us to prosecute our case on behalf of everybody, even the unnamed, unknown victims, and get a giant class settlement for them as well. Very big threat. And I've been told, I don't know if this is true, but I've heard from other firms that TCPA suits, including class actions, are up possibly 50% in the last year alone. Where can they sue you? Ryan mentioned this earlier, but there's this relatively recent case, the Mims versus Aero Financial, which said in the Mims case, a big company had been sued in federal court, and they said, no. Look at that language in the code up above here on the top of the slide. Look at that language. This is about state courts. You can't sue us in federal court. And the district court said, yeah, you're right. Dismiss the plaintiff's lawsuit. It was appealed. The circuit court said the same thing and dismissed the case. Went to the U.S. Supreme Court. U.S. Supreme Court says, no, we think the federal courts also have jurisdiction. This means, for the most part, consumer can sue you just about anywhere. You can sue you in their local small claims court, rush and get to trial in 2 or 3 months and get a little $5,000 or $10,000 judgment. They can sue in their state trial court or in big, bad federal district court, in which you might spend 2 or 3 years in court and tens of thousands of dollars in outside counsel litigation fees, win or lose. All right, how do you deal with these TCPA suits or threatened suits and AG letters and stuff? Remember that these suits, or even just the threat of them, these demand letters, they're costly and distracting and stressful, whether you win or lose, whether you're in the right or wrong. The sheer volume of these professional plaintiffs out there are on the rise. There are guys that my office has dealt with that have told me convincingly that they make a 6-figure income suing telemarketers. Our office doesn't do tons of litigation. We focus on the compliance, but just for our existing compliance clients, we've been forced to deal with, I want to say at least on a weekly basis, we're resolving suits or threatened TCPA suits. Just the volume of these are going up. The plaintiffs are becoming more and more savvy. Plaintiff lawyers, the plaintiff's bar, if you want to call it that, these telemarketing lawyers that will sue telemarketers for individual plaintiffs, they're on the rise. They're spending more money marketing. Just Google telemarketing lawyer. You'll see a lot of my firm's sites, but you'll see a lot of these plaintiff telemarketing firms now spending a lot of money to advertise on Google and sign up people who have been receiving robocalls. Never ignore these demand letters or the AG letters. Don't ignore them. It won't go away. It will only escalate it. You may get lucky 1 out of every 10 or 20 times and call someone's bluff. But for the most part, neither the regulators nor these private plaintiffs are bluffing. They're savvy. They know the rules. They know their rights. A lot of these guys are pro se, and they sue on their own. They don't need a lawyer. They don't need to pay a lawyer. They figured out their local court forms, and they even know how to go and garnish out of your bank account if they get a judgment. You'd be surprised that some of these guys have really learned the system well and can come after you. Even if they're in the wrong, they can cause you a lot of cost. Ask regulators or plaintiffs for extensions if you need it, but don't ignore them. Cooperate, be respectful. How do you avoid liability for TCPA suits? Well, fully comply with the rules. Be conservative in how you read the rules. Comply and retain proof. Be able to prove it easily. If you get sued, obviously you should at least consult with counsel on the best way to defend. A lot of us have dealt with these guys. Some of the usual suspects. We know their MO, what money they want, how you can make it go away. I mean, I hate to say it, but sometimes it makes sense to pay these guys off rather than, sometimes just, the mathematician in you just wants you to write the $3,000 check rather than a $10,000 or $20,000 check for some big litigation firm in whichever state you happen to have been sued in. But on the whole, if you can afford it to stand up to these guys, I think that's good for the industry. If you know you're in the right, fight back, especially for you big companies that can afford to do so. Don't always bend over. Don't always force your vendors and call centers to step up and pay these guys off no matter the cost. That might please the bean counter in the back room and save you a few bucks this year, but what about in the long run? I mean, these suits are on the rise. We'll see a flurry after October the 16th and even more next year. You just shouldn't be writing checks willy-nilly. Investigate the case. Be nice to people and respectful and do negotiate, but don't just write checks. If you need to put your foot down and defend yourself and your vendors, do it. Okay, finally, conclusions, tips. Act quickly to deal with the new wireless consent rules. Carefully analyze your dialing software. Are you using an ATDS? Don't just consider your own opinion, but what do you think the government would say based upon their guidance in the past cases? How do you deal with the cell phone issue? Either get the consent or identify and scrub out cell phones or manually dial. Remember, all these new dialer rules, these are dialer rules. You can still manually fat finger punch in 10 key. You can still do that to cell phones and residences even after October the 16th. These new rules target the use of automatic telephone dialing systems, not manually dialing. So if you can manually dial, then you don't even need to scrub out cell phones. But a lot of us, because of the agent downtime, can't afford to do that. So get your consent if you can. If you need to cold call, then at least identify what cell numbers are on your list and fat finger dial those, or manually dial those, or scrub them out if you're just convinced you have to auto dial everybody. A lot of great vendors out there, including DNC.com. Call Ryan. Get yourself at least a few quotes on wireless identifying and scrubbing services. Just doesn't make sense to do it in-house for most call centers. It's not always the case. Promptly resolve consumer complaints and government inquiries. Give out refunds. Make people happy, even when you know you're in the right. If some angry guy, gadfly out in the middle of nowhere in Kansas calls you and says, you robocall my cell phone and I never consented, even if you know you're in the right, if you had an exemption or consent or something, don't make him mad. Try and explain it, but just be nice. Apologize. Give the money back. You don't want them hanging up the phone mad and calling their state AG or running and getting an attorney. If nobody complains about you, nobody pays attention to you. Be nice to people. Resolve consumer complaints to their full satisfaction. Same with the regulators. Give refunds. Do what you need to do. Don't escalate the situation by arguing with people. Seek proper consent to call at every point of contact with your consumer or customer. If you're doing auto warranty for dealers or something, the dealers you work with, get consent when they come and test drive or buy or when they're on a website. If you're a vendor for a call center, make sure your call center, or make sure you're let's say you're a vendor for a big timeshare company, rather. When someone comes in and stays at a resort or tours or participates in a promotion or logs into your website or creates a profile, you want to be constantly asking them for consent, to call them. Build up those consents. It's tough to do, but you may very well be able to generate the right consent you need. And if you can't, then again, a lot of great vendors ready to help with wireless identifying and scrubbing. Finally, remember, the EBR exemption is gone for autodialers. You can't just robocall your past customers anymore. It's still an exemption to DNC, but find creative ways to re-engage your past buyers or even no bias and inquiries. Through careful adaptation, our industry will survive and flourish. There's lots of money to be made despite the new rules. The floors that won't be with us next year are floors that did not adapt quickly enough and weren't willing to make the investment to tweak their systems and get new scrubbing in place and get new legal opinions that they need to sleep easy at night. We'll survive. The call center industry is great. It's good for our country. Generates tax revenue. It's a large employer. It helps innovators and product developers and sellers reach out to consumers in a very important way, and we'll get through this just like we did when National D&C came about. But we got to get on this now, guys. We're about 3 weeks out. That's it, Ryan.
Well, thank you, Eric.
Interesting questions, maybe. I know I went a little over here.
Yeah, we got a lot. We also had a lot of people join us today. I think we're almost up to about 435 people. So
wow.
Obviously
the sheer number of attendees is staggering on this. If we don't get to your question today, let me get this slide up. Send Ryan an email, and we'll get back to it in the next few days.
Yeah,
what can we go over now?
I think what we can do is try to go through a chunk of the questions and try to highlight a few of the confusing areas. I know for us, with our clients and people we've been dealing with, it's just a matter of really sitting down and doing a one-on-one with the company and figuring out, okay, what do you have now? What is your intention after the 16th? How do you make calls? Are you going to use a dialer? Do you want to scrub wireless in-house? Do you want to outsource it? We can do both. So let's talk, and we can try to figure that out. And then Eric can help you with the consent language and how you need to interpret it and getting that legal opinion about how your dialing is going to be TCPA compliant, because most companies use some sort of a dialer that falls under TCPA. Even ones that I know that it seems to me they're not even really using anything. They don't even want to be mixed up in it, and so they're doing things to at least have a separate process for cell phones, because, like, the whole theme of the webinar was really about the super sacred cell phone. You got to have something to put into place. Once I think the rule actually effectively becomes active, you're going to see a lot more press about this too. So you're going to see people on the news channels, guess what? Now they can't call your cell phone. So, you've got 3 weeks to try to get consent from the consumers you have now and get at least some campaigns out where once that gets closer and consumers get more aware of it, your success ratio of trying to get people to opt in with that specific disclosure language is going to go down, unfortunately. But there are ways to call cell phones, and the good thing is when we do our suppression or ID, we extract them in a way that you can identify clean cell phones versus landlines and be able to put those together, put them into your campaigns. So let's go through a couple of the questions here and try to figure out if we can't get to all of them, obviously, so we'll pick out a few. The couple things, too, there was a lot of questions about the slides and whether we have a follow-up on that. So we'll have the slides or a link out to get the slides for people afterwards that we'll email out. And then we also will have this recorded. We have a YouTube channel that I'll probably upload this to, that you can view it there. And we also have the webinar where we'll put it in our compliance guide. So we have an online resource for tracking all the regulations and some of the FCC statutes. We'll post it there as well. So let's talk about some of the things that are out there in the industry. This is a couple of questions covered this. What about the outsourcers in the industry? What kind of consent do they need? What do they need to verify with their clients? How much should they be concerned with TCPA or wireless scrubbing? I'm talking about the outsourcer, the call centers, the firms that specialize in having a variety of clients and running campaigns on behalf of others.
Good question. Keep in mind, like you mentioned, every situation is a little different depending on what the business relationship is. It depends on if you're calling on behalf of, are you calling using the name of the underlying product seller that you're calling on behalf of, or are you calling under your own name, et cetera? So, case-by-case basis, I have different answers for you. But the general rule is, if you're an authorized dealer for a big home security company, for example, and you're just a third-party vendor, if your account client has consent to call, they can share that with you, and you can call as their third-party third-party telemarketing agent using their name, and you can call on their behalf, and you get that consent. Or you could try and get the consent for you specifically to call. But generally, I'd say the safest approach is make sure the seller has the consent. If you're a third-party call center vendor that works with a number of different big account clients who are the actual widget maker sellers, you should be working with them and coaching them about how they can generate the proper consent. If you're also hiring third-party online lead generators, you want to set up long-term relationships where a website lead gen company can build your name or the sellers you work with, their business names, into their online consent language so that you're generating consent that will allow you to call on behalf of your seller account client. So yeah, a seller can hire a third-party telemarketing vendor to call on their behalf so long as that seller has proper consent to call.
So that is definitely very helpful. I think the other thing that I've recommended is people address this in their contracts with their outsourcers. So, figure out who's going to do the scrubbing, who's going to do that filter. If it's going to be daily usually or real time, that's usually a good place to start to try to get it to, the highest level possible so that if you do have litigation and if Eric's got or whoever your legal is going to help you out, you've got the ability to go in and say, hey, we've scrubbed our records every day. We've scrubbed them as much as possible. We're going, hyperdrive compliant, I think is what a lot of companies are trying to do, just so that they don't end up in a situation where they, could be paying thousands or be tied up in court for 2 to 3 years. That doesn't sound fun.
Yeah, and that's a very good point, Ryan, about the contracts. Whether you are the widget seller and you're hiring a third-party call center, or maybe you're the third-party call center that wants to work with some big insurance company or timeshare company or whatever it is, you want to make sure you carefully negotiate and draft those agreements such that the compliance burdens are spelled out. Who's going to do the wireless identifying and scrubbing? Who's going to worry about storing consents? Who's going to maintain the opt-out data on your opt-outs? I mean, make sure there's no, someone can pick up your contract and read it, and everybody's on the same page.
So the other question that came up quite a bit was about the rules around texting or SMS messaging and how they're treated under TCPA. Basically, like Eric talked about, they're treated like a call, but specifically, like what happens if somebody opts out on text? Does that apply to a call? Do these rules apply now? How do I get consent? I mean, can you kind of shed a little light on that?
Yeah, the short answer is, and that's a complicated question, again, just depending on what exactly you want to do. But the short answer is that the feds already consider a text essentially the same as a phone call. And if you receive an opt-out by text, then unless you're very careful how you set it up, I mean, you're going to have to put them on your opt-out list, unless you're specifically allowing opt-out for text only. But you're not allowed to do this. I guess it just depends on exactly what you want to do. But the bottom line is a marketing-related SMS message that you transmit to a consumer is treated just like you were transmitting a telephone solicitation. Now, certain things won't apply, call abandonment. But for the most part, you should. I tell my clients, just treat it as if it were, kind of like a robocall. You have to provide an opt-out. You have to honor the opt-out. I think that's I'd have to think about the question as to exactly what happens if they reply back stop or something. Does that mean you could never call them again? I don't think that's necessarily the case, but to be safe, I would treat it like an opt-out across the board through all mediums, maybe. Again, there's a spectrum of liability on a lot of these questions. There's going to be multiple different approaches, and there's going to be one where you read the rules the super conservative, strict, safe way, and you try and think like the craziest, most anti-business regulator. You try and say, what would they say about this? And then take the most conservative approach. Or you could make the business decision to accept a certain amount of risk and just try and manage it, and maybe you only apply that text opt-out to text, and you keep emailing and calling. But for the most part, the feds are going to treat a text like a phone call under these new rules. And the consent is the same, meaning you cannot transmit a text solicitation to a cell phone, whether it's a business or consumer cell phone, without prior express written consent, unless you meet one of the other very limited exceptions like HIPAA or something.
Here's a question that came up early on. What if a call is initiated by an autodialer, then transitions to a live operator? Is prior express written consent required for the call to a residential line?
So now let me make sure I understand it right. Are you saying it was a predictive?
It just says autodialer, then transitions to a live operator. So to me, that is a predictive dialer. That is
so it was predictively dialed.
Then it was, and then they popped an agent on the phone.
And was it a landline? I think they said landline.
It says called prior to a residential line. Yeah, so that must be a landline.
Well, this is the good news in that scenario. The new rule only restricts pre-recorded messages to landlines. For cell phones, the new rules restrict both pre-recorded and predicted, basically all forms of ATDS. But for landlines, it's a little more narrow. So yeah, you can still predictively dial a consumer on their landline. And again, this is the federal rule. Some states are more restricted. But you can use a predictive dialer to call a residential line without this new heightened written consent, even after October the 16th. So yeah, that would be acceptable if I understand the hypothetical correctly, which I might not have.
Yeah, I think you got it right. The other thing that I was going to mention, and a couple of people asked, was about, like, okay, let's say they're doing manual calls. There's cell phones in there. What is there to be concerned about? One, I think, would be the definition of what their manual call or whatever system they're using. The other is that the one thing that wasn't in your presentation, but we always tell clients on, or advise them on, is the 5 states that you can't manually call in. There's Texas, New Jersey, Arizona, Louisiana, Wyoming for cell phone calls. Even a manual call, if it's telemarketing related in those states, can cause a problem, or it's illegal, basically. So that's one that, it's just a matter of, like I said, talking with us one-on-one, working with either our system or getting the data, and then help, having a compliance partner. There's one more thing that you can worry about, which is the state issues that have always been there. But in this case, these states know that they have extra rules around it, so they tend to enforce them. So
so a limited number of states just ban telemarketing to cell phones, like you mentioned. These new rules are technology-related rules. They restrict autodialers specifically, but be aware, even if you're manually dialing, a lot of the old rules still apply. There are disclosure rules that every telemarketer has to follow when they call. Even if it was genuinely a manually dialed call, you've got to tell them who you are and what the true telemarketing purpose of your call is, and your telephone number, address, etc. There are certain disclosure rules. There are prepayment disclosures you have to make before you take a credit card, for example. Also, the national D&C list. It doesn't matter whether you're robocalling or manually dialing, you still have to honor the D&C list and not call numbers on that list unless you've got an exemption like EBR. So yeah, there are other rules to follow even if you're manually dialing, but the good news is you don't have to deal with the dialer restrictions specifically. You don't have to deal with automated opt-out and getting written consent, and it's just a different ballgame if you have a call center that can afford to do manual. And like Brian said, be real careful. Make sure you really are doing manual. Is the desk phone you're using to do quote-unquote manual connected to a computer? Are you using any software to facilitate that? Is it your CRM, and when you're in there and you open up the profile on a client and you click with your mouse on their phone number and it calls it, is that what you think is manual? I mean, be real careful and scrutinize your system and make sure it's not an ATDS if you're going to rely on that.
Yeah, that's definitely good advice. can you clarify, this is another couple areas of questions about the difference between collecting like on past customers, running your own collections, third-party collections versus telemarketing, and how these kind of rules, the amendments specifically change or don't change things for folks, because I think people get confused between, well, I'm doing collections, either I just need to worry about wireless, but then you get some recent decisions that make it seem like that they're maybe looking at it differently. You kind of point people in the right direction.
Well, how these new rules affect the collections industry is deserving of probably its own entire webinar, but short answer is that, yeah, debt collectors get some breaks when they're calling to collect debt, but a lot of the rules still apply, including some of the new ones. The Nelson case that I mentioned, Nelson versus Santander, decided in March. That was the big $500,000 judgment. That was against a debt collector, I believe. Also, there have been, for a long time, the feds have they've kind of been they gave an exemption to the debt collection industry that kind of flew in the face of some of the things the statute said. For example, for the longest time they said, look, if a borrower provides their cell phone number in the usual course of business to the creditor, then we're going to treat that as express consent to call that number, even though that's not express consent. That's implied consent. And certain courts have picked up on that, and they said, look, we do not care what the FCC is saying about this exemption. It flies in the face of the TCPA, which says express consent. This doesn't say implied consent. Just because they gave you your phone number when they finance their car or something doesn't give you the right to robocall their cell phone for the next 100 years after they default. That we're going to ignore the FCC guidance and stick strictly to the statute, and you're busted. Here's your enormous judgment. So as a general rule, debt collectors need to follow this. They need to identify and scrub cell phone numbers unless they have the proper consent or manually dial. But there are a lot of complexities there we just don't have time to get into, and work with us offline. And I know DNC.com occasionally will do a webinar that's more focused on debt collection.
Yeah, we tend to have been doing webinars, it seems like almost every couple of weeks since the rules are getting closer. Typically we do one once a month, but we've done some in the past that have been more slanted towards collections, and we represent a lot of collectors that they want to scrub cell phones or get the data in-house. So it's definitely a larger population than before, since the rules have been not only amended but also kind of ruled against in terms of some of the decisions in the local court cases. Not many of them have gone in the favor of the debt collector. It's mostly in the other side towards the plaintiffs. So we've definitely seen a lot more interest in that vertical. And so certainly, yeah, I mean, anybody that's looking for help with that, they can reach out to us. We'll follow up with the slides and get people the recording from today too, so if they need to explain this law, which it's definitely complicated enough to do another webinar closer to the date coming out. But the other thing that people have asked about, now that we've kind of explained a lot of this stuff, Eric, is there any relief in sight for a rewriting of the definition of a dialer? Will there potentially maybe be some guidance on whether at least preview mode would be allowed or not allowed, or any kind of movement at the FCC level in terms of the rules coming out? I mean, October 16th is a drop dead date as far as we've been telling our clients, but as far as like any movement, as far as I think the collectors are trying to do what they call modernize the TCPA, but I don't know if you've heard anything.
To be perfectly honest, I'm not. I know there are petitions pending, and various members of our industry, law firms and big call centers and big companies, are trying to work with the regulators and make them see the light on some of these issues. And some of us feel that certain of the regulations, or at least how they're being applied, is really unreasonable and silly. I mean, is an ATDS really anything that could have the capacity to store or generate numbers sequentially or to auto dial? I mean, every cell phone has a computer processor in it. What about the speed dial function on my phone? I mean, could that be an auto dialer? I mean, that would just be silly if you took it that far. But we've seen courts and regulators do crazy things, and I don't see anything on the horizon, any big date or hearing or an announcement, impending, such that I would feel safe to take the wait and see approach. You need to conservatively interpret the rules and only rely on preview dialing, for example, if you're confident your system is absolutely not an ATDS. It is wholly incapable of auto dialing. Even if you're not using it that way, it can't generate or dial randomly or sequentially. It can't do things like predictive and pre-record. Even if you paid the extra fees for the licenses and turned on other functionality, that the functionality doesn't exist on your platform or with your program. So be very, very careful. Don't take the wait and see approach. There is nothing I see in the short term coming in terms of clear answers on this from the regulators. They have been letting us guess on so many important issues for so long. I just wouldn't count on them making it more clear in the near future.
Great, yeah, definitely. Let me give people a couple pieces of information that they wanted. One is somebody wanted to repeat the 5 states that you can't manually call to a cell phone or a wireless device. For those would be Texas, New Jersey, Arizona, Louisiana, and Wyoming. Texas, New Jersey, Arizona, Louisiana, and Wyoming. That's 5.
And I don't have the list in front of me, but there are a bunch of states that have restrictions on dialing generally that aren't cell-specific.
Right, that's a lot of
some states, there are states that don't want you to auto-dial even if you have consent. I want to say there's one of those or something. But just be aware, yeah, states are all over the board on these types of rules, and some more restrictive than the feds.
There's also a couple other types of phone numbers that have been brought up as far as being, potentially covered by TCPA. There was a case, and somebody asked about it.
The
VoIP case, yep.
That is scary.
So the weird thing about that is there's like no national VoIP database. We've been able to work with one of our partners to build out a way to purge for VoIP numbers. But it's not necessarily going to be all VoIP numbers. There's no national database to pull from like with Newstar. So, we're able to provide that service, but there's no guarantee it's going to be 100%. But some companies have taken a look at it because they feel like they at least want to do something around that area because they've got the vulnerability because of the case. And I think Eric can probably explain it better than I can. But basically, somebody claimed that they were incurring charges on a VoIP line. Therefore, they went out and tried to sue some company over the under the TCPA. So
in fact, look at this. I went back to the B2B slide because it's got some of the code on this that applies here. Look in the middle there, beginning what I've got in brackets. The new rules protect any telephone number assigned to a paging service, cellular telephone service, specialized mobile radio service, or other radio common carrier service, and here it is, or any service for which the called party is charged for the call. That's how they got him in the VoIP case, is the guy was able to convince the court, look, TCPA is talking about me because, on my plan or whatever, I'm paying for these VoIP minutes or whatever. And I'm not an expert on that case and don't know tons about it, but it's my understanding that he was successful in asserting the protections that apply under the TCPA to a cell phone to his VoIP line. So very scary. Yeah, how do you know if you're calling a line that's, goes through VoIP or something? I mean, it sounds like you guys are developing some sort of solution, and maybe there'll be more technology or a list in the future. But like you mentioned, there is no big, consolidated official list of VoIP numbers.
And that's the other list that supposedly is going to be coming out, which is the PSAP list, the Public Service and Answering one that's been in debate.
Anytime soon. You're right. There's potentially a new do not call list coming out for emergency lines, essentially. The problem is they're scared that once they've created that list and made it available to call centers, that someone could get a hold of it. I mean, there are almost national security risks involved. What happens is if someone posing as a telemarketer signs up and buys that list and then uses it to, blast every emergency answering point in the country or region or something. So there are some big security, safety-related concerns that have kind of stopped up the development of that list. But it's coming. I mean, potentially, they've the feds are working their way slowly to that. But there's just some big concerns right now.
That makes sense. And I think, a lot of the other questions that we kind of went through, we'll definitely feel free to reach out to us one-on-one. We're offering kind of like a free kind of mini wireless kind of compliance consult and even a test scrub if we need to try to help people figure out what their impact is and get things, looked at for compliance-wise. And with some of the levels of some of the things out there, especially around whether calls qualify as like informational or whether the script that people are using or forms for opt-in, all of that really we're trying to send through a legal source just because this is the most complicated thing we've seen. Do not call was one thing, but the TCPA and all the nuances and then the changing court cases, it's a lot to tackle.
You have to be careful on that. Remember the old the once popular survey approach where, well, we're not selling anything on the phone. We're not pitching a product or taking credit card information. We're just doing a survey. And then they turn around and audit that data and sell the leads to others who will make a solicitation potentially at a later time. Feds came down pretty clear and hard. Nope, that's telemarketing because we don't look at your call in isolation. We look at the broader plan or program. I think, for example, the FTC defines telemarketing as any call that's part of a plan, program, or scheme ultimately intended to result in a sale or something along those lines. So they'll look at your overall strategy and say, is this telemarketing related, even if this particular call and this particular individual script doesn't contain solicitations? We still consider it telemarketing because of X, Y, Z. So be very careful in trying to get around the broad definitions of telemarketing and telephone solicitation.
Yeah, the last thing I checked is that 500 or 1,500 times really any number gets big real quick, and then you get the FCC pointed at you. We've also seen a couple of the carriers. We run into a couple of our clients that have, they had problems because they weren't doing the right thing with cell compliance, and they were calling a lot of people on a couple of carriers, and they got sued by the carriers because the carrier got mad that they were getting a lot of complaints from their customers.
We've seen suits from a lot of different angles like that.
Yeah, so I appreciate your time, Eric. I think you kind of went over everything in a real kind of logical format, which is good without getting too much of the heavy lifting case law, but certainly we'll have another one of these coming on, and we're going to be having a compliance event in November, most likely November 14th in Miami Beach. We're just finalizing that, and that'll be coming out in an email to you sometime very shortly here.
And that'll be a full day, a lot more in depth.
Yeah, and more of a chance to really dive into some of the nuances and background and other areas that are related that you can't really cover in an hour here. But we're really trying to get people set up with kind of a good guidepost for the new regulations and getting them with the right partners and actually still make phone calls. That's the whole goal. So I'll get those slides out to everybody this afternoon and link to the recording and everything. I should have all that done fairly shortly. So look for that.
We've got our emails up there. So I don't know about you, but I'd probably prefer email follow-up questions rather than flooding the phone lines. But our contact information is up there.
Yeah, either way, and look forward to also seeing people potentially. Are you going out to Washington, D.C. for the PACE meeting?
Absolutely. I'm booked. Yeah, PACE, formerly ATA, PACE Professional Association of Customer Engagement, holding their big Washington, D.C. Compliance Summit here in a couple weeks. We'll get to interact with regulators and talk about the new rules, and a lot of good stuff to be learned.
Yeah, so anybody's going out there, I think we'll be able to meet up and discuss things.
Yeah,
I know
I'll be there.
It'll definitely be interesting to see what the regulators have to see, but we will definitely follow up with folks and appreciate everybody joining us today and putting up with, somewhat of a duller subject, but I think right now it's definitely there's a lot of interest because of it's a very controversial thing what's going on. And so hopefully people will bring that to the folks that they work with and make sure they can translate this information all the way down the food chain. Thanks again, Eric.
Awesome. Thank you, guys. Thanks, Brian.
Bye.